It's time again to ask the attorney, and here with us is Darrell Minton from Minton Marion Law Firm, here to get some of your questions answered that you've submitted to him. Welcome.
Thank you.
All right, well, we'll get right to our first question, and that is, do I need a lawyer to go to small claims court?
There's no legal requirement that you have a lawyer. You can appear pro se, which is a Latin term. Lawyers like to use those. It makes us sound more mysterious and intelligent. I have met some brilliant lawyers, but mostly not so much. I've met a lot more brilliant plumbers, pipe fitters, mechanics, and moms. The point is, if I were to have to wire a ceiling fan, I'd probably burn the house down. If I were to try and operate a washing machine, this shirt would be pink. But if I'm going to do something that's not my area, I'm going to consult the appropriate professional, and in this case, it would be a lawyer. I see pro se litigants all the time in the courtroom, and sometimes they do just fine. It kind of reminds me of a squirrel crossing the highway. Sometimes they get across there just fine, but it's usually because someone made a special effort not to run over them. Sometimes they get across and they decide for no apparent reason to run back the other direction and they get run over. And it's kind of in a sick sort of a way funny to watch a pro se litigant try to use the words they learned on TV to defend themselves, but usually the result is kind of like it is with the squirrel. The good news is that you can appeal a judgment in a small claims court, but there are some hoops that you have to jump through and some strict time deadlines. So what I'd recommend, if it's not feasible for you to hire a lawyer, at least consult with one before you get into that, so you have someone on board and ready to handle that appeal should you get run over.
All right, our next question. I got hit by a truck driver and it broke my wrist. His insurance company won't pay my bills and I can't work. Can I sue his insurance company?
Well, you can, but more than likely the case will be dismissed. The proper thing to do is to sue the driver and his company, then the insurance company has to defend them. But let me caution you, don't settle your case without consulting with a lawyer. There could be hospital liens, Medicaid liens, other liens out there. You may be required to reimburse your own health insurance company for the bills that they paid. If you don't cover those costs with the settlement proceeds, you may get sued yourself. So always consult a lawyer before you settle a case or sign anything. In fact, in a personal injury case, call us before you start talking settlement with the insurance company and let us help you get through that without any traps along the way.
All right, now our third question. I got fired and my boss refused to tell me why. Don't they have to put that in writing?
No, we get people that assume this every day. Unless your employer is a state agency or you have a written contract, you are in Texas what's called an at-will employee, and that means that you can be sued for a good reason, a bad reason, or no reason at all. But conversely, it also means that you can quit anytime you want to for a good reason, a bad reason, or no reason at all. It works both ways. There are more exceptions to every rule than there are rules in the law, and the biggest ones in that case would be a termination based on improper motivations such as racial discrimination, discrimination based on age, sex, disability, or some kind of a prohibited retaliation claim. Come see us, maybe we can help you, but if you smell blood in the water and you think someone is being discriminated against and going to be fired, come see us before that happens and maybe we can help protect you.
All right, some good tips. And you can get your questions answered every Wednesday. Just go to fox4beaumont.com, click on Ask the Attorney, and submit those questions.